Hello and welcome back to the Blackstone Solicitors channel, where we make legal matters clear, practical, and relevant to your everyday life. Today we're discussing a topic that affects nearly every household and business in England: utilities contracts. Whether it's electricity, gas, water, or internet services, utilities are something we all rely on. But while most of us think of them as straightforward, the contracts behind them are often more complex than they appear. Understanding your rights, obligations, and potential pitfalls is crucial, especially if disputes arise or you want to switch providers. At its core, a utilities contract is an agreement between a service provider and a consumer or business, under which the provider supplies essential services, and the customer agrees to pay for them. These contracts set out key terms, including the duration of supply, pricing, billing, payment methods, and what happens if either party fails to meet their obligations. Many people assume that utility services are automatically provided, but in reality, these contracts are binding legal agreements. Signing up for a new energy tariff, connecting to a water supply, or even arranging business broadband involves entering into a contract that carries legal obligations. A utilities contract usually contains several essential elements. First, it will define the services being provided and the duration of the contract. Some contracts are fixed term, which means you are committed for a set period, while others are rolling or flexible agreements. Next, there are obligations regarding payment. The contract will specify how and when payments should be made, what happens in the event of late payment, and whether interest or penalties apply. It will also outline the provider's responsibilities, such as maintaining supply, providing accurate billing, and responding to issues or outages. Another important aspect is termination and renewal. Contracts often include clauses explaining how you can end the agreement, any notice periods required, and any fees that may apply if you exit early. Understanding these terms is essential to avoid unexpected charges or complications. Despite appearing straightforward, utilities contracts can give rise to disputes. A common issue is billing errors. Consumers may be overcharged, charged for services not received, or billed incorrectly after switching providers. These disputes can usually be resolved directly with the supplier, but sometimes legal intervention is necessary. Another frequent problem is service interruptions. While occasional outages may be unavoidable, prolonged or repeated disruptions can be a breach of contract, particularly for businesses that rely on continuous supply. Customers may be entitled to compensation for losses suffered as a result. Fortunately, consumers and businesses have legal protections. The Consumer Rights Act 2015 and the Supply of Goods and Services Act 1982 provide safeguards, including the right to services that are performed with reasonable care and skill, accurate billing, and fair contract terms. For energy and water services, specific regulatory bodies oversee compliance and can help resolve disputes. Understanding your contract and seeking expert advice before entering into or exiting a utilities agreement can save significant time, money, and stress. At Blackstone Solicitors, we help clients review contracts, resolve disputes, and ensure their rights are protected when dealing with suppliers.